So I'm Sandra A. Stars. I'm a professor here, as you can tell by my silly banter. I founded the Arts and Entertainment Advocacy Clinic here, I don't know, about 8 years ago. And I'm a member of the CIP2 team. I'm the Senior Fellow for Copyright Research and Policy. And it is my pleasure to welcome you all to this panel on generative AI and human authorship. Questions about what is art and who is a creator have long captured the minds not only of artists themselves, but of philosophers, scholars, innovators, lawyers, policymakers, and pretty much anyone who is involved with or interested in the creative process. Certainly me, and certainly all of these folks on the panel today. The Copyright Act, as you might know, does not answer either one of these questions directly. There's no definition of art in the Copyright Act, and certainly many things beyond those that aspire to purely aesthetic goals are copyrightable. Maps and charts, software code, documentaries, scientific and historic literary works, to name just a few examples, are all copyrightable. Don't have to be art to be copyrightable. Recently, questions surrounding art and creativity have come to the attention of the creative world yet again and to the general public. And this time, they're animated by interactions with generative artificial intelligence. So you've probably heard about or used tools, generative AI tools like Midjourney, DALL-E, and Stable Diffusion. These are all tools that are capable of producing new images, text, music, and other complicated outputs in response to a user's textual prompts. And the widespread use of these tools is raising a variety of questions about how current copyright, and not just copyright, and I'm going to emphasize this because it's way more than copyright, that's involved here, other IP laws and related laws, and maybe laws to be, how those should be applied or updated to fit these innovations. And I'm making this little kind of comment, maybe laws to be, because in fact, just yesterday, Senator Chris Coons, Marsha Blackburn, Amy Klobuchar, and Tom Tillis introduced the No Fakes Act. And the No Fakes Act would prevent a person from producing or distributing an unauthorized AI-generated replica of an individual to perform in an audiovisual or a sound recording without the consent of the individual being replicated. And there are other proposals on the Hill that would require transparency and disclosure and labeling of AI works. So sort of a nutrition label for the information and entertainment marketplace, if you will. But back to the copyright world, a common way that people have been analyzing the issues that come up in the copyright space is by starting with mapping copyright law and considering whether the tools themselves are infringing copyright law by virtue of how they operate or how they're trained. And many artists have raised concerns that the materials on which GAI tools are trained consist of vast amounts of copyrighted works that are copied and used without permission. And so there have been lots of lawsuits filed so far against all the major developers of GAI tools by visual artists and by authors and stock photo agencies and others to test these theories. There are other key areas of inquiries, and those center on authorship issues, whether the outputs that a generative AI tool creates deserve copyright protection. And thus far, we've had a few information points that we can examine with the panel. There's a case involving a work supposedly created entirely by an AI, the creativity machine, which the US Copyright Office and the federal courts have ruled is not entitled to protection because there was no human authorship involved, and so no copyright protection adheres. That answer is pretty straightforward and based on longstanding US case law and can be easily applied if there's really no human authorship. But what constitutes human authorship where the lines are less clear? And where to draw the line if you have an artist who's using an AI tool to execute their creative vision? Or what happens if an artist begins a work by prompting an AI and then finishes it by making adjustments and modifications afterwards? And what about the infringements that an output might create, right? How should we apply copyright infringement doctrines like substantial similarity and defenses like fair use to the outputs generated by AIs or humans using AI tools to assist their works? So these questions, these lovely, wonderful people sitting next to me are going to help answer. So we've got 4 insightful panelists to help us probe these questions. Just in no particular order, John Tehranian is the Paul W. Wildman Chair and Professor of Law at Southwestern Law School. He's also a visiting professor at UCLA School of Law and the founding partner of One LLP. Van Lindberg, I'm telling you the order that I'm going to ask questions in, so they're not seated in that order. But Van Lindberg, who is not seated next to John Tehranian, as you have probably deduced, is a partner specializing in IP law at Taylor English, and he represents clients at the intersection of computer technology and the law. Molly, who is seated between the two of these fine gentlemen. Molly Stech is general counsel for the International Association of Scientific, Technical, and Medical Publishers, and she's an adjunct professor at American University School of Law. And Keith Kupferschmidt, who is next to me, is the CEO of the Copyright Alliance. And the Copyright Alliance is a nonprofit, nonpartisan education and advocacy association that represents the collective voice of copyright owners in the United States. So I'm going to start with Professor Tehranian and ask him to help us understand how we should analyze generative AI technology against copyright law's relevant doctrines. That's just a really small question.
Yeah, well, easy question, right? So it's a pleasure to be here. I want to thank Sandra for the kind invitation and the center as well for hosting this great conference. So for me, when I look at this issue, what's old is new again, and legal controversies around generative AI actually raise a whole bunch of issues that have actually festered in copyright law for decades, if not really centuries, and that includes the issue of subject rights. So, I think to understand this, one thing that's instructive is going back 150 years and looking at the iconic case of Burrough-Giles v. Cerrone. That's, of course, the case involving the copyrightability of photography, which is, involved not only issues of subject matter, but also implicitly involved issues of what authorship consists of and who the author is. But before doing that, I kind of want to take a step back when we talk about generative AI and kind of share some words of wisdom I like to reflect on when dealing with new legal issues. And one of my favorite quotations ever is by an individual who was one of the first copyright law professors, Benjamin Kaplan. And he had a great line that he wrote in a book in 1966 called An Unhurried View of Copyright. And he wrote the following. He said, "As a veteran listener at many lectures by copyright specialists over the past decade, I know it's almost obligatory for a speaker to begin by invoking the communications revolution of our time and then to pronounce upon the inadequacies of the present Copyright Act." Now, he wrote this in 1966, right? And we kind of have a tendency to do that. Look at new issues and suggest the Copyright Act is wholly inadequate, and that's not always the case. There are some answers sometimes in the pre-existing doctrine, the common law that has been set out. And to quote Benedict Evans, who's a technology pundit, he wrote, "This is a completely new problem, generative AI, that we've been arguing about for 500 years. So it's not really a completely new problem. And really the history of intellectual property is reacting to new technologies and an evolution of the regime, whether it's through common law or statutory reform. obviously AI involves a lot of challenges in terms of both authorship as well as in the infringement front. On the ownership front, we have questions about who should be the owner of the potential output. There are many choices here. It could be no one, it could be the AI companies, it could be the prompter, the user, it could be the existing copyright holders for the content upon which the model is based, or it could even be subjects who are featured in the works, or some combination of that. On the infringement front, what are the permissions required? Is there infringement at the level of scraping in terms of the AI generative training models? Is there infringement at the level of the model training? Or is there infringement at the output level? And if model training is an infringement, there are questions as to, whether our own brains are generative AI that is engaging in infringement at all time. After all, we are the ultimate generative intelligence, spitting out content based on all the works we've been exposed to through the course of our lives. And there's also an interesting question, I think, that may be predictive in terms of how the future goes with respect to how YouTube dealt with infringement on its network and its content partnership program, which cut in rights holders. Might we see the emergence of contracts as a solution to route around the complexities of the copyright problems? No matter what, these are a lot of questions, right? And there are very, very few answers, at least at the current time. And this is fantastic news for copyright lawyers, right? In a sense, it's not only everything that's stimulating about intellectual property, what drew us to this field, the intersection of technology and art, philosophical questions about the nature of authorship, but on top of this is going to give jobs to a lot of copyright lawyers for generations to come. So in terms of looking at Cerrone, that I mentioned about earlier, a starting point, one of the interesting things, of course, about Cerrone was it addressed this debate of, is it science or is it art? And is there authorship in the human use of technology to render a fixed kind of output? That sounds quite familiar to the generative AI issue. As you recall, of course, in Cerrone, the Supreme Court ultimately held that although photography is part science, it also is part art, and that there was sufficient human authorship in the creation of photographs, even though that was through a tool of capturing, light on photosensitive paper, and it also captured mere facts. And so, there is some precedent there for engaging in this issue of human authorship. But one of the very interesting things about Cerrone is it presumptively put the authorship rights in Napoleon Cerrone, the fixer of the image, the individual behind the camera. And in a sense, this is kind of an error. It's an erroneous reading of Cerrone because Cerrone actually did no such thing. In that case, there is a very small line that's seldom been given attention, which is that the court notes that Napoleon Cerrone and Oscar Wilde, the subject of that photo, had contractually agreed that Napoleon would be the owner of the photographs, the author, if there was going to be an author found. So the court actually never addressed the issue of authorship. And in this area, I said earlier at the outset of my comments that there are festering issues in copyright jurisprudence. This is one of the biggest. Who is an author? The Copyright Act actually doesn't give us any definition of authorship. In the 200 years where we've had lots of copyright jurisprudence, there has been scant direct jurisprudence defining who an author is. And for many years, we have ignored the creative contributions of people in front of the camera, as opposed to those behind the camera. People like Oscar Wilde, who through the development of his image, through the creative choices he made in the setting and the pose and the expression he provided, actually contributed authorship. Now, courts in some ways have head off some of these points in recent years, like the famous Garcia v. Google decision, which suggested that fixation is authorship and subjects have no rights in their copyrights. But it seems that generative AI in this debate over control, especially with things like the No Fakes Act, is going to bring to the forefront this issue of subject rights. And it's one of the many issues that generative AI promises to bring, and I just want to focus on that for now. So thank you.
Thank you, John. So you have touched on a number of really interesting issues. And before delving into them further, I want to give each of the panelists a chance to sort of lay out their opening thoughts. And so I'm going to move next to Van Lindberg. And just so the audience knows a little bit more background about Van, Van represented the artist Chris Kostanova, in their attempt to register copyright in the graphic novel Zaria of the Dawn, which was created using Midjourney. And Van, you were only partially successful in your goals because the Copyright Office disagreed with you regarding whether the work was basically one of human authorship, with the AI being merely an assisting instrument for the artist, or whether the traditional elements of authorship in the work were actually conceived and executed, as the Copyright Office said, not by Kostanova, but by Midjourney. So could you please comment on how you think we should analyze the use of GAI technology in light of the relevant copyright doctrines, and maybe tell us a little bit of background also about the engagement with the Copyright Office?
Absolutely. First of all, I'm glad to be here. Let's make sure that this is close enough so you can hear me. Let me tell you just a tiny bit about, actually, before I go, I'm going to tell you my thesis, and that is that the current doctrine of the Copyright Office is not tenable, and it will change. And it's probably going to change sooner rather than later, but sooner may be a series of years. Now, let me tell you a little bit about Chris and the process that Chris went through in generating Zaria of the Dawn. This was an original story that was written, and they had a really full concept of what these things, all the things that were going to happen in this graphic novel. And so to go along with each of the captions that were previously written in the story, Chris went through many times hundreds of iterations, creating one prompt, tweaking the prompt, adding what are called image prompts, previous generations as ways to influence the outcome, until they got to the final set of images that they wanted, which were then cropped and placed in context to make the full comic. When the Copyright Office looked at this, they said, "Do you know what? You don't have enough control." There was randomness associated with the process. You weren't the one who actually did this. Now, first of all, I think that is just ridiculous, because if you look at the images that Chris created through the entire comic book, they were consistent. They had a consistent look. They had consistent characters. They had a consistent point of view. There was no way in which something that was completely random is going to have a consistent view, look, characters, etc., through an entire comic book, unless there was creative control. Now, I appreciate Professor Tehranian bringing up Cerrone, but the reason why I think that the Copyright Office was so wrong is because Cerrone was not the end of it, at least with regard to photography. The thing that they only quoted Cerrone in their decision, where they said, okay, the selection and arrangement and the original text are copyrightable, but any individual image is not. That's what the Copyright Office said. But in Cerrone, one of the things that was interesting is that what they said made it copyrightable was not the process of actually capturing the image. It was all the other stuff that was done around the capturing of the image. The lighting, the posturing, the costumes, the directing and invoking an expression, all that stuff. But Cerrone left open this idea of, well, maybe things that did not have as much stuff, did not have as much involvement around the actual taking the photograph, maybe they weren't copyrightable. Who knows? The case that really, at least for photography, changed this was Blistein v. Donaldson in 1903. Now, this is usually thought of as a case associated with commerciality, high art versus low art. But there was a phrase that, perhaps taken out of context, that really changed the scope and the discussion around the copyrightability of photography. And that was that Holmes said that the copy was the personal reaction of an individual upon nature. Personality always contains something unique. It expresses its singularity even in handwriting, and a very modest grade of art has something irreducible, which is one man's alone. So in Holmes's view, it was this originality that was the original contribution, the personal stamp, not the intellectual labor. And Holmes really shied away from making any sort of artistic judgment associated with what is good art. He simply said it needs to be original and original to a person and bear some portion of their stamp. Now, this view of copyright that was all you needed was the bare minimum of originality informed the next century of photographic copyright cases. And there was one called Jeweller's Circular Publications versus Keystone in 1922. This was by then District Judge Learned Hand. This was again not high art. It was a directory of pictures of trademarks from different jewelers, but it included commentary on that where it said, Judge Hand said, Burrow-Giles left open an intimation that some photographs might not be protected. I think that, even as to these Blistein rules, because no photograph, however simple, can be unaffected by the personal influence of the author, and no two will be absolutely alike. Moreover, this all seems to me to be quite beside the point, because under Section 5J, in the earlier Copyright Act, photographs are protected without regard to the degree of personality which enters into them. At least there's been no case since 1909 which has been held to be a condition. The suggestion that the Constitution might not include all photographs seems to me to be overstated. This view actually has persisted. This is the view that was discussed in Geist. This is the Zapruder film case where they said, oh, you just happened to be there, you didn't have the originality. The judge there went through all of this stuff, quoting Cerrone, Blistein, Jeweller's Circular, and said it is the rule that it is going to be per se copyrightable, and that is where we have landed. Nimmer on copyright says that is, with very few exceptions, the rule for copyrights today. It's going to be the same because right now, they're in the Cerrone phase, but very soon they're going to get into the Blistein phase, where they realize as soon as people have as soon as there is a person who puts some individual stamp on it, it should be copyrightable, at least by default.
Thank you, Van. And let's move to Professor Stech, who has recently published articles about copyright's originality doctrine, as well as on the role of the subject in copyrighted works. So she is very well positioned to comment on both of Professor Tehranian's and Van Lindberg's comments. But I'm curious whether your work or any follow-on research has provided you with insights on how we should think about GAI technologies and human authorship. And feel free to comment also on your co-panelists' presentations so far, if you'd like.
Great. Thank you so much, Sandra, and thank you for the invitation. It's a pleasure to be here with you all. And just as a caveat, I'm General Counsel of STM, but my comments here today are my own. And I think as opposed to starting out with commenting on either Van's or John's opening remarks, I'm just going to start with a premise that a human is an author, and we haven't really touched on that specifically, so I'm going to go there and then maybe wait for later in the conversation to comment on photography, for example. Lastly, my brain has been elsewhere for a couple weeks for my day job, so I'm going to stick a bit close to my notes, if you'll forgive me. So turning back to humanness, I think there's ample evidence that humanness is a prerequisite of authorship. Beyond the monkey selfie case that many of you are probably familiar with, there's explicit reference in the U.S. Copyright Office compendium and references in case law to human relatives of an author, for example. And of course, there's the fact that the entire concept of moral rights in the Berne Convention, that's attribution to the author and integrity of his or her work, wouldn't make sense without a human author. As Sandra mentioned, and my co-panelists as well, creativity and originality tend not to be defined in domestic laws, but they do nod to human authorship or reference it in other ways. For example, France has an imprint of personality test, and the Court of Justice of the European Union has an author's own intellectual creation test. I think it's okay to take kind of a rational and careful approach to this question and think about it through the prism of all the other parts of copyright law that have long accommodated questions and problems for which no bright lines exist. I'm thinking about the idea expression economy, fair use, of course, registrability of arrangements of common shapes, and other areas. We know that by way of case law, some copyrights are thick and some are thin, and I think this sliding scale remains viable and is actually very important in the AI space. A simple analog analogy, of course, is that an editor of an anthology of books will receive a copyright for the selection and arrangement of books in that anthology, but not for the content of the original books themselves. Another example is that is something every copyright student knows about the Bird Girl case. This is Lee versus Warner Brothers from the 11th Circuit in 2000. Here, Jack Lee, a photographer, was commissioned by Random House to take a photograph for the cover of the book Midnight in the Garden of Good and Evil. Mr. Lee discovered a statue in the Bonaventure Cemetery known as the Bird Girl, sculpted by Sylvia Shaw Judson. When Warner Brothers then created a movie based on the book, it obtained permission from the sculptor's heir, but it had its own photographer take a similar photograph of the Bird Girl statue. The original photographer, Jack Lee, only had a thin copyright in the creative elements of his photograph, but he couldn't maintain a copyright monopoly in photographing that statue. And so similarly, I think to the extent that an author has used AI as a tool in completing a copyrightable work, that author will be able to benefit in copyright protection for the aspects of that work that were the outcome of his creativity. Or in European parlance, again, that's the author's own intellectual creation. Or as Professor Jane Ginsberg has put it, authorship has two components, conception and execution. I think we might need a case for generative AI like we had for photography in the Mannion case. This is a Southern District of New York case from 2006. So it's only a district court opinion, but it outlines three ways in which a photograph can be deemed creative: rendition, timing, and creation of the subject. And going back to the Tehranian case, that made photographs copyrightable, but not all photographs are copyrightable. Lastly, it seems unfeasible at this point, I think, that the user of an AI can use so much skill and creativity in prompting an AI that copyright inheres. For example, some people are Lexis power users, but that doesn't mean, I think, that they're the author of the search results or the arrangement of those results, nor is a video game player the author of his play of that game, because AI, going back to the AI context, work on a finite data set that they've been trained on. And there's some interesting scholarship by Dan Burke and Daniel Gervais that talk about causation, again, similar to I think what Professor Ginsberg was saying. So I think I'll stop there for the moment. Thanks, Sandra.
Okay, thank you, Molly. And so to wrap our conversation up, at least the initial round of it, turning to Keith, I know that as the CEO of the Copyright Alliance, and I sort of intimately know this, you have a unique perspective on this and many other copyright issues because you represent such a diverse cross-section of the creative community. So what can you share with us about the creative community's views about how generative AI should be treated under copyright law?
Excellent, thank you. Hopefully, let me move this a little closer. Everyone can hear me, hopefully. I'm going to talk about something a little bit different. I am going to stick to just generative AI as opposed to all different types of AI. But I'm going to talk mostly about what I'll broadly call the ingestion process here. And first of all, I want to thank Sandra and my other panelists here for being up here with me today. And for asking me to speak. As the only organization that represents the interests of the entire copyright community, perhaps the most important thing about AI and copyright that I've learned in talking to our members is that, I guess somewhat unsurprisingly, AI impacts each different copyright industry differently. And when I use the word industry here, I'm referring to everyone within that chain, whether you're an individual creator, you're a copyright owner, you're an organization, maybe you're administering those rights, things like that. And the reason it affects each industry differently is because each industry has its own business models, different business models, but also because there are different provisions in the copyright law itself that will apply to each of them differently. But perhaps most importantly, AI impacts the copyright industry differently because the AI models themselves impact them differently. And maybe I'm not saying anything earth-shattering here, but if you are familiar with a large language model, an LLM, it's very different and works very differently than how a music model works. In that, for instance, an LLM may need to copy some threshold amount of text. But when you're talking about a music model, that really isn't the case. In fact, it may not need to copy very much, if any, music at all, since there are a limited number of notes, chords, chord progression stems, and things like that. So what does this mean? Why am I talking about this? What this means is, as policymakers start considering copyright-related AI issues, it's important that the question that they ask is not how AI impacts the copyright community as a whole, because that is the question they're asking right now. That's not the right question. What they should be asking is how AI impacts the book publishing industry, how AI impacts the music industry, how AI impacts the motion picture and television industry, and so on. Because the impact is going to be different, and therefore the responses and solutions should be different for each separate industry. Now, despite their differences and the different ways that AI impacts the different copyright industries, there are 5 fundamental principles that they all agree on, at least when we have our discussions internally, that they all agree on, with regard to ingestion of copyrighted works by generative AI developers. So let me go through those, and then we'll kind of I'll throw it back to Sandra. So the first principle is, when formulating new AI laws and policies, it is essential that the rights of creators and copyright owners be respected. So when making determinations about AI policies, it's vital to understand that any new laws or new policies relating to AI must be based on a foundation that preserves the integrity of the rights of copyright owners and, importantly, their licensing markets. The interest of those using copyrighted material for ingestion by AI systems must not be prioritized over the rights and interests of creators and copyright owners. The second principle is that long-standing copyright laws and policies must not be cast aside in favor of new laws and policies obligating creators to essentially subsidize AI technologies, and that sort of is what's going on now, unfortunately. Established copyright laws must not be weakened based on a mistaken belief that it's necessary to do so in order to incentivize AI technologies, or that AI technologies will fall apart if all of a sudden copyright laws are respected. Now, this is especially true when there's no evidence of market failure warranting changes to the law, and we've yet to see any market failure here. The third principle is that ingestion of copyrighted works by AI systems implicates the right to reproduce copyrighted works. The law is very clear. I think everyone here probably knows this. When someone makes a copy of a work, the copier has infringed the reproduction right unless either there's a defense, like fair use, that's applicable, that excuses the infringement, or the user has a license from the copyright owner. Under the Copyright Act, a copy is made whenever a work is fixed sufficiently to, and I'll quote the Act, be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. That is a very, very low standard and is very easily met. Importantly, there is no requirement that a copy be retained or stored, only that it exists for, quote, more than a transitory duration. Now, some have also argued that what they are copying is merely unprotected data that is extracted from ingested works. And that's a little bit of trickery, a little bit of sleight of hand. So to be clear, these AI systems typically copy entire works, the whole thing, including all the expressive elements of a work that merit copyright protection. That AI companies may extract and retain data about those works while discarding the works themselves does not change the fact that they copied entire copyrighted works, an act that constitutes copyright infringement unless there's a valid defense. Let me move on to number 4, principle number 4, which frankly is probably the most important of all of these. The ingestion of copyrighted material by AI systems is not categorically fair use. Some AI developers argue that ingestion of copyrighted works by AI tools always constitutes fair use. That is incorrect. Determining whether a particular use qualifies as fair use, I think as we all know, requires a fact-intensive inquiry that is considered on a case-by-case basis. There are no uses that are always categorically qualify as fair use. Likewise, there are no uses that are never fair use. Now, based on the 4 fair use factors, the typical ingestion of copyrighted works by a commercial generative AI system is unlikely to qualify as fair use. In part, this is because under the first factor, ingestion is unlikely to be a transformative use, since the output generated by these AI systems will often serve the same exact purpose as the work ingested. And as discussed yesterday, even if the use was, in fact, held to be transformative, the Supreme Court made clear in the Warhol decision that that would not be dispositive of the fair use inquiry. In addition, under the 4th fair use factor, ingestion is likely to have a significant adverse impact on the value and market of the copyrighted work. And this is especially true when copyright owners have made licenses available in the market for AI training, which we are seeing more and more of. And the very last point I'll make, number 5, is that it is essential that AI companies license what they ingest. No AI-related copyright laws or policies should be adopted that interfere with the free market or interfere with the freedom to license. Where a copyright owner offers a license for uses related to training of AI systems, it is essential that those licenses be respected by any copyright or AI legal regime. So I will stop there and turn it back over to Sandra, and we can talk a little bit more about these issues.
Thank you, Keith. I was writing furiously here because I had all these questions planned out in advance that I was going to ask, and now I had to throw them all out the window, react to what you're saying in real time here. And this means the panel has to react in real time too, because you know that the first question I'm going to ask is for you to react to what Keith just said. But first, I want Keith to answer one thing, which is what is the implication of your principles here for the ability of, for instance, some of the artists who you represent, independent artists who you represent, to actually use AI tools for creative work in their own practices? Are they using them? Can they use them? Are there any tools that are ethically sourcing their training materials?
Yeah, I mean, there are quite a few tools out there that are doing the right thing. And by the right thing, I mean they're acting responsibly, ethically, and respectfully, right? In terms of, I think Adobe Firefly is a very good example of that. We see right now different AIs produced by like Shutterstock, Getty, I think. I'm not sure if they've actually launched their new one yet, but it's going to be out soon if it's not out already. And there are others that will attempt to do the right thing. And what we have found is twofold. We have seen creators that want to do the right thing. They want to kind of use, individual creators want to use AI, or at least experiment with it and see how it can be used as a tool, but they're also not sure about the legal implications, and so they just like won't do anything, right? They won't use this because they may not necessarily know kind of whether a particular tool is kind of abiding by the law or not. And then there are others that do know that and will use tools that they know are in fact ingesting works and have licenses to do that. And so we're seeing right now, honestly, we're seeing a mix. I mean, this is their very, very early stages, and so I think we're all trying to get educated in terms of, how the creative community can use AI as a tool. We've got members that have been using these AI tools for many years, like movie studios and record labels and what have you. And then we have newer, individual creators who are just starting out right now, trying to figure out how to use these tools. And it's a big balancing act, and it's a lot of education too. But I think the first step in doing all this is to making sure that, like I said, the AI developers are doing the right thing, are acting ethically, responsibly, and respectfully.
Okay, so I'll ask maybe Van as the first person, because you represent both artists who are using the tools and technology companies that are developing the tools. So what are your thoughts on Keith's suggestions?
So, whoa, is this on? Is this on? Yeah, there we go. So, first of all, I think it might be useful to identify a couple of places where we do agree. Yes, fair use is a nuanced inquiry. It is going to depend upon the exact use. I think that also, if anyone says that they know exactly what the answer is in this case, they are lying, because no one knows exactly where things are going to come down. Until the Supreme Court rules, all bets are off. That said, it is my opinion that it is highly likely that ingestion of copyrighted materials for purposes of training an AI model should be and will be considered a fair use. And that is, so you have to understand that there are different things that you need to discuss differently. There are the outputs of the model, which is part of what we've been discussing. There's the model itself, which is some software and a pile of statistical tables that are referred to as weights. And then there are the inputs. You need to consider each one of these things in isolation and their particular uses and the ways in which they are used. Now, I do agree that there is a copy that is made in the process of ingesting a work, but there is a specific, there are specific, that is only because it is on a computer, and it is a necessary step for any sort of perception of a work to make a copy on the computer. And then what happens in the basis here, you said, oh, they just throw it, they extract data and then they throw away the work. It's even more than that. Can you imagine if someone took a book and they opened it up and they counted all the verbs, the number of verbs in it, and they counted the number of conjunctions, and they counted the number of nouns, and they counted how often an adjective came before a verb. Then they wrote down these tables of all these measurements. There's no way in the world that you'd say that this table of measurements is a derivative work of the book that I just read to make all these measurements. That is all that these things are doing, is they're creating a statistical view, a statistical table of whatever the things that they're brought in on. And as Warhol identified, you have to look at, is this thing actually a market substitute for the work that would be supposedly infringed? And again, this is where you have to take things and you have to look at the input, the output, and the model separately. The model itself, like I said, is some software and a pile of statistical tables. There's no way in the world that that can be a market substitute for the input work. And then the output work, it's true that in some limited cases, which are actually bugs, it can reproduce one of the inputs. If it reproduces one of the inputs, it's a copy, it's infringing, period. But in most cases, you cannot, you don't have a translation from the input directly into the output. And there's no way to actually draw any inference from any particular input to the output. And so unless you can say that the output is a market substitute for this specific work, not for the artist's work in general, copyright just doesn't apply in that case. Now, I'll pause. I know I'm being spicy here.
Yeah, I definitely want to bring John in on this conversation and also particularly ask him to bring in some of the conversation around right of publicity and the subject's rights as well. I did want to make one, I think, slight intervention on your description of the facts, because I think I'm not incorrect in saying that a lot of these data sets are not, in fact, thrown away, and that's how, say, the Books 3 data set came into being, where the scraping of data sets occurs. They are maintained somewhere, and then other sets are laundered either from legit sets or from scraped sets elsewhere. And
Books 3 is highly likely to be infringing. I mean, it hasn't been judged, but yes.
So in any event, that's the only intervention I wanted to make. So John, your comments on Keith and Van's
Sure. Well, first I'll address Keith and Van's point, and then I want to obviously address your other question about the right of publicity and subject rights. But with respect to the training of AI, I lean more towards Van's view than Keith's view. Not because I think it should not be infringing, but rather because I think the existing precedent actually makes a very good argument, although nothing is certain, that at least the training of models will be deemed to be fair use. And the reason I say that is one can look at the recent emphasis of transpurposive uses in fair use jurisprudence. Although the Goldsmith case kind of cut back transformative uses, where you're making kind of a new work, it certainly did not cut back on the high level of fair use given to transpurposive uses. In fact, if anything, it emphasized that even more by suggesting that when you're using something for a very different purpose, it is not creating the same kind of market harm to the original work. And I think that's certainly the case with respect to the training of AI models. One need only look at the recent cases involving sort of transpurposive use with respect to creating thumbnails, for example, right, for search engines, the Google, the Perfect 10 v. Amazon case, or the Hathi Trust case with respect to the scanning of all the books and digitization of all the books in the world, which was ultimately found to be fair use. Again, it's transpurposive use. Now, I say all of this not saying that I believe that that should be the outcome, but rather that that's the likely outcome. But I also think that we also need to think about the output, right, as a potential source of infringement. And I think there's a much stronger case for infringement, not just when you have errors that Van noted that create works that are almost identical to the original, but also the whole cascade of derivative works that output is made possible through these generative AI models. And there may be liability that attaches not just to the users that are entering the prompt and creating infringing output, but arguably secondary and maybe, given despite volitional conduct requirements, maybe direct liability for the AI creators in terms of the output. So there's a secondary legal case to be made for infringement that doesn't rely necessarily on what might be fair use vis-a-vis the training of the models. Now, with respect to Sandra's question on the right of publicity, and this kind of ties into the No Fakes Act, I think one vehicle for the preservation of subject rights through the years, of course, has been the right of publicity. But I think this is a deeply inadequate vehicle. And particularly so in terms of relying on the right of publicity to enforce subject rights and the creation of deep fakes or other generative AI that implicates subjects. And the reason for this is the right of publicity is a patchwork. It is 50 different or 51 different rights of publicity throughout the United States. Every state has a different level of protection. Each right of publicity in every state is subject to different sort of First Amendment or state constitutional limits on expressive rights. There are copyright preemption issues with the right of publicity. And perhaps most importantly, the right of publicity everywhere requires some kind of commercial misappropriation. So courts have to determine whether something is more of a merchandising use or not. And I think when we talk about the use of subjects in the AI context, particularly when we're talking about deep fakes, we're not necessarily trying to vindicate purely commercial interests. We're also trying to protect people from the injury that occurs through reputation from a deep fake, dignitary interests that are non-commercial, and so perhaps we want to have a protection mechanism that goes beyond the right of publicity that protects subjects even when there is not a commercial use of their image. So to that end, of course, the No Fakes Act, which seemingly creates a quasi-federal right of publicity that happens to last lifetime plus 70, sounds familiar, could be one solution. Another solution would be vindication of subject rights through trademark law, although I think that's been attempted in the non-generative AI context, has deep limitations because of the emphasis on likelihood of consumer confusion. Or perhaps my favorite route would be a reevaluation of copyright law, and in terms of the way we vest rights and interests in an author and whether subjects may be considered authors. I think this is helpful in the way that it could trigger a conversation about looping in subjects into the eventual compensation schemes that emerge through the use of generative AI. And we've kind of seen this model work with respect to the digital performance right, where subjects have been looped in through the performance right that's collected by Sound Exchange. Or we've seen this with SAG-AFTRA getting residuals for its performers for the exploitation of copyrighted content.
Thank you very much, John. And Molly, I want to ask you to weigh in as well, both on what Keith suggested and his back and forth with Van, but also on this issue of subject rights, which I know is very much a subject close to your heart.
Sure. Thank you, Sandra. And yeah, these are two very different questions. Starting with Keith, I agree with all of your 5 points, which is probably not surprising to you. I guess one thing I'd like to pick up on with respect to one of your last points is, going through the fair use test for any given set of content or data, it just drives me crazy that a lot of time content is just called data in the context that it's ingested. But I know, of course, that not all AI systems are created equal, nor is all ingestible content created equal. For my members, these are journal publishers, Elsevier, and medical and scientific journals. I guess I'd just like to point out that the content that they create and to which they own the copyright is, it's peer-reviewed, it's enriched with metadata, it is highly curated, and it's just really high-quality data. Going to the fourth factor of the fair use test, it's something for which a market exists, I believe, that some AI systems will really want this high quality data, And to that point, I think the fourth factor would weigh against fair use for the ingestion of that kind of content and for a lot of content. I'll stop there on that issue. With respect to the very different topic of potential rights for subjects of photographs, this is something I wrote a law review article for this organization a couple years ago, and so it's not at the front of my mind at the moment given my day job, but I guess I would tie it back to my original comments insofar as what we're talking about is human creativity. And I'm very sympathetic for an argument there that the subject of a photograph, for example, Oscar Wilde, but for the fact that there was a contract in place between Napoleon Sereny and Oscar Wilde, there, the way that he presented himself, the facial expression he had, versus what Napoleon Sereny contributed, which was a lot, which was what the Supreme Court talked about insofar as the lighting and the drapery. I just think there's, two humans contributing creativity in that photograph, and that there's potentially some that it's not always the case potentially that only the photographer is the author of a photograph.
Yeah, I mean, there are certainly examples. I mean, the image that comes to my mind is the model Ratajkowski, where she was being photographed by a paparazzi, which photojournalists hate that word, but she's being captured, and she didn't want to be photographed at that moment. But, she also didn't want to, so she had various choices. She could have turned her head. She could have given the finger. She could have covered her face with her hands. She had a bouquet of flowers in her hand. She put a bouquet of flowers to cover her face. It's a beautiful image. The image gets captured by the photographer. So who owns the rights in that image? Is it the photographer completely because the photographer was there to capture the image at the moment? Or should she have some rights because she contributed to the subject? The photographer could not have anticipated that that was going to be the composition. She was the one who created the composition. It was her idea to raise the bouquet. He did not say, hey, put the bouquet up in front of your face and hide your face because I'm going to take your photo, right? So I think that's, that is maybe even a better example than Oscar Wilde sitting in a studio.
Yeah,
right?
and she was sued for using
Right, and
that
she
image.
used it
I mean,
on
that's
her-
the big kicker, right? Is she ends up in
used it on her blog,
litigation
and
and saying my image is not my own.
Right.
Right. So, and there was a lot of expressive value in terms of the commentary she made in terms of showing that image as a protest against this notion of the fact that her image is not her own. And she
Right.
wrote a whole book on it, of course.
Right.
Can I respond to
Please.
some of the things that were said here, just to pick up on some of the Van said earlier about sort of that this is just data, like unprotected data that's put into a data table. And let me follow up with the example that he gave, which is a literary work, right? And for the AI models to work, which in the LM area, you need to know like the relationship between different words so that the model knows, okay, after this word, there's a good chance that this next word's going to appear and things like that, right? So, and attach a certain value to that. Well, let's take a step back and think about what copyright is, what copyright protects. Copyright protects expression, doesn't protect the facts. So if you're talking about a literary work here, like an article or a book, the author of that is making a creative choice in what word to choose. It's then making a choice what the next word is and the word after that, right? Those are relationships, right? And they're patterns. And what copyright protects is those word choices, the order of those words, okay? The order within the sentence, then the order of one sentence next to another, and the sentences within a paragraph, and so on and so forth. That is the essence of copyright protection, okay? What the AI community likes to call relationships and patterns and data is actually copyrightable expression. And you take that and say that's not protectable, copyright is completely eviscerated. That's the first point I wanted to make. The other point I wanted to make in response to what John said about sort of precedent, AI, we are in new territory here. There are cases out there, whether it's Happy Trust, Google Books, I mentioned some of the thumbnail cases as well, that will certainly be instructive, right? But that's all they are, is instructive. If you look at the facts of those cases and you look how the law applied to those facts, it is very, very different than what we have taking place here, right? In the Google Books and Happy Trust case, for example, you had basically the copying of books to provide information about those books, okay? Not the books themselves, not to allow people to create new books. What you have in the AI environment is you're copying books, you're copying artwork, you're copying music to make more books, more artwork, and more music. Very, very different scenario. The other very different scenario is that there was no licensing market, okay? For those, there was no licensing market for search engines. There is a licensing market for AI ingestion. It may be just starting, but there is certainly a licensing market for that. Another big difference is they were copying legitimate works. A lot of these models are indiscriminately scraping the internet, including pirated websites. Now, in Harper and Row, it makes clear that you cannot have a fair use defense where you knowingly or should have known that you were using something illegally. The underlying work was an illegal work. And after Harper and Row, that was supported in the Atari case. So for all these models that are indiscriminately scraping the internet, I don't think they can take advantage of fair use at all, at least with regards to those works that they scrape from those pirated websites. And there's a lot of other differences between these other cases. I think we are in new territory here. If we ever had time, I'm happy to get into debate and go factor through factor, the four use factors. Sandra would kill me if I did that now. I'm happy to do that because, I mean, it's hard to do without an actual factual scenario in front of you because this is fair use after all. But in the typical commercial generative AI case for ingestion, I'm not talking about output. I think output's a very different instance. But for ingestion, I think it's very unlikely to be a fair use. And like I said, I'm happy to go through each of those factors.
So I might ask you to do that unless somebody has a question from the audience, and there are lots of questions, so you don't get to do that just yet. So, I think we have a mic somewhere that we can get to you.
So, Keith, think about the reductio absurdum of what your view entails. My mind trains on all sorts of copyrighted content. I learn English and the ability to express myself and make all sorts of creative works. So what you're really saying is you want copyright to have a licensing market for reading, not just for copying, because my brain copies.
Yes, no, I'm not saying that at all. You're very different than, at least I hope, a machine, a computer, right? You're not making a copy. A computer's how? Okay.
It's called short-term memory.
Okay. You are not making a copy that is actionable under the Copyright Act, whereas opposed to a computer is. And so therefore, since a copy is being made, that implicates the reproduction right. I don't think there can be any doubt about that. Now, unless you have a license, or unless it comes under some defense like fair use, like we were talking about, that is going to be considered to be an infringement. Now, let me also add one more thing. You talk about these works that you probably went to school and paid for some books along the way, I would imagine, too, right? So
are you referring to RAM copies?
Yeah, RAM copies are certainly part of what I'm referring to.
RAM copies are almost by definition volatile. They are not fixed.
Okay, MAI versus Peak says that. If you even look at the Cartoon Network's case, it says that. That's not correct.
That's the way it works in memory.
Okay, but there's a difference.
In fact, really in a equivalent way. What the AI system does is parse it. Parsing is equivalent to reading.
In the act of doing that, if you will, okay, it is making a copy.
It's parsing it. It's
You can call it whatever you want, but at the end of the day, it is copying, and copying is actionable under the Copyright Act, under the reproduction right.
Right, but leaving that aside, my brain, I mean, I'm getting older. I can't reproduce the way I used to, the imagery that I've read, all of the art, all of the music. And, you know, I'm just not that aesthetic. But I can do a lot of it. And the whole point of ingesting all that stuff is to make creative outputs. So what you really want to do is extend the copyright to control the brain. I think that's just an awful idea, and you should be ashamed of yourself for trying.
No.
So, all right, it sounds like we don't have an actual question in there. Is there can we get the mic up in front to the lady in red?
Thank you so much. Good morning. My name is Delbar, and I'm from JMU Law School. My question is, like, I'm already saying the bad consequences of artificial intelligence in law field, where the submissions are actually made by the artificial intelligence, and the consequence, I was saying that the court was discouraging lawyers using the artificial intelligence because they were like citing all of the cases wrongly. And I am also like witnessing how students are getting addicted to their homeworks being accomplished by the artificial intelligence, which is actually like dismotivating them from doing the analysis, the reading comprehension, and all of the stuffs. The question is, what is actually the government or the United States right now is doing to somehow limiting artificial intelligence to breach the, I would say, like, artificial intelligence now is being unlimited. It's getting unlimited. What the government or what the people are doing to somehow limiting the scope. Thank you.
So the question is are there are the panelists aware of any government activities regulating or putting any scope on artificial intelligence that would be relevant to how it is used by users? And she was particularly referencing some of the law uses, the famous misstep by the attorney who was caught up in citing a lot of cases that didn't exist in a New York instance, and what happens sometimes to law students who don't do their homework properly. If you have any advice as to how we can keep folks like that in line.
The EU has the AI Act that they are working on, which has this idea of high-risk activities, which are places where people, property rights can be at risk due to the output of an AI. Mostly in the U.S., no, although there are a few incipient state things. I'm not really familiar. Then there are a number of people who are saying we should take an overall pause in AI. But overall, legally, those are the only things I'm aware of.
Yeah, I was going to say, there's some bills that have been introduced in Congress. Nothing has passed yet. I'm assuming you're talking about like bills relating to labeling things as AI or some level of transparency and things like that. But nothing has been enacted yet. With an election coming up next year, I would imagine there'll be a little bit of a rush to do something in that particular area. But so far, there's nothing in the United States, as far as I know, that has enacted. I mean, our focus is solely on copyright, and labeling and transparency is sort of ancillary to that.
I mean, to some degree, the question of whether you can claim copyright in the output may influence how people use AI in creating a work. So if you can't get a copyright on the output of a work. If you've used AI to create it, that might limit the interest in using AI to actually create a work. And to the extent that, for instance, in your law school class, as here, some of the policies are that you're not allowed to use AI in the drafting of papers, for instance. You may be dissuaded from doing so if your grade depends on using it, right? Or similarly, if you can't submit to a law journal for publication, if your final product is used, is using AI, that's a similar sort of dissuasion.
In large scale, what I mean is like people are getting used to the infringing and showing the product which is not theirs as theirs, and this is kind of rooting people to infringe the copyrights because they initially it's not theirs. It is the artificial intelligence product, and they are like at the end of the day they are stating that this is their piece of paper. But initially, it is the time and effort of someone else, which we don't know.
I think maybe, if I understand your question correctly, you're getting a little bit about what's called copyright management information, and there is a provision in the copyright law, section 1202, that protects the integrity of copyright management information. One of the things that we want to make sure is that if there's some type of labeling of artificial intelligence, that falls within CMI. So, for instance, we would not want, for instance, someone to take, let's say, some piece of music or a movie or something like that and label it as AI so people think, oh, this isn't protected by copyright, and the inverse is also true.
So I think we are actually at 11:48, which is 3 minutes past our end time. So I will ask you all to thank the panelists for their contributions to our discussion.